A very good evening to one and all present here, and welcome to the valedictory and closing ceremony of the India ADR Week 2023. I would like to invite Mr. Madhukeshwar Desai, CEO and founder of MCIA, to give the opening remarks.
Respected Justice Vikram Nath, respected Mr. Tushar Mehta, ladies and gentlemen, I don't think I can emphasize how important it is and how nice it is that every single one of you are here in the room today, despite what is happening outside. I'm very happy to speak to you about a couple of things. I'll be brief, of course, because we're all waiting to hear from our dignitaries. Last Sunday, the MCI completed 7 years. I'm still quite in shock in how the past 7 years have passed. But I'm not going to go over everything that we've done in the last 7 years, but I thought I'll just highlight the last 1 year and a few statistics that would sort of emphasize what it is that we have achieved in a small period of time, in a very short period of time. Just last year, in 1 year, we gave out 24 awards. In those 24 awards, 92% of them were completed within 18 months. Of that, only 3% were challenged in a court of law. And every single one of those challenges were dismissed. The one statistic, however, that I'm most proud of is 38%. 38% of all arbitrators that were appointed by the MCI were women. It's a challenging task, but the MCI is committed to diversity. It isn't enough that the MCI is led by a woman. We want to make sure that we don't just talk about diversity, but we implement it as well. When we completed 7 years, I looked back at my opening remarks that I made at the inaugural of the MCIA. And at that point, I'd said something that we have stuck to. I said that the MCI does not want to be an ivory tower, a tower of perfection. We may have achieved an impressive number in terms of our caseload and what we do in terms of efficiency, but that isn't why we are established. We do not want to be an ivory tower of perfection. We want to build an ecosystem that benefits lawyers, law firms, government, business houses, young practitioners, arbitrators, and all stakeholders. And the India ADR Week is part of that commitment. The India ADR Week, and I will give complete credit to Neeti, she came to us and she said, let's do 5 days of events across 3 cities in India. And the first reaction was obviously absolutely not. You're absolutely nuts. Nobody is going to do 5 days of events. People aren't going to come. People aren't going to speak. People aren't going to listen. But I'm happy to report that we started in Bangalore on Monday. We had a full hall. We thank God and moved on to Mumbai. We started at 8 a.m. We had a full hall. During lunch on Monday, the hotel ran out of food because we had made a minimum commitment and we had double the number of people that showed up. On Wednesday, we had a full hall, and the same repeated on Thursday, Friday. And of course, I've emphasized why it is so important that everyone is here today. We have not just, and the reason that people have come, it's very difficult to get people into a room today because you have to emphasize why it is that you're asking for their time. And we're asking for their time because we're having dialogue with every single individual on important aspects of the law, important aspects of arbitration, important aspects of the practice, important aspects of what is happening across the world and in India, and what it is that each one of us can do, contribute, and help out as stakeholders. And I think that is the message that we want to give out with India ADR Week. That we may be many states and many union territories, but when it comes to a purpose and a cause, that we will all come together and make sure that we portray and demonstrate to the rest of the world that we're here to show you that we are an extremely important jurisdiction. I'd like to highlight 2 other aspects that we have accomplished during the India ADR Week. We've had our commitment to younger practitioners. It's important to build a pool of arbitrators, and to our commitment to our younger practitioners, we have actually started the Tribunal Secretary Program. The Tribunal Secretary Program is the first of its kind in India. We had a cohort in Mumbai, and we had a cohort here in Delhi. I'm happy to report that it went very well. We're going to put the list of tribunal secretaries on our website, and we hope to have them appointed very soon. The other one that, the other commitment that we've made is to Use Mundi. Use Mundi is an important platform. We've signed an MOU with them, and we are going to be publishing redacted MCI awards on the Use Mundi platform that will be available not just in India, but globally. In 2016, we did one more thing radical when we started off. We invited EPIC, at that point in time DTI, to fly down to India, and we put a screen next to our stage, and we had live transcription. It was an extremely expensive process, and it was very novel at that point in time, to a point where everyone thought that we were reading off a script. I'm very happy to share that 7 years later, we have an Indian organization that is now doing transcription at our event, and it's the same organization, of course, that did the transcription at the Supreme Court as well. And that these services are now available to parties at India, and that is more accessible to everyone over here. The last one before I close is that, yes, I'm here in my capacity as the founder and CEO of the MCI. I'm very proud of what we have done and what we have achieved, but it is equally important that we build this ecosystem along with other fellow institutions as well. I would like to believe that we are an umbrella organization and not one that is just in competition with other organizations. And to that end, through the India ADR Week, we have had 20 other arbitral institutions that have either supported or have spoken or have participated or have had independent panels or have come to our events and also explained why their institution should be used. And I think that is extremely important when we're building a jurisdiction or we're building a nascent jurisdiction and telling the entire world why it is that we work. If you leave me to speak about the MCI, of course, I'll go on for a very long time. But all I'd say is we've started well, and we're going to announce the dates for next year, next week. And we hope to have next year bigger, larger, better, with more participation and stronger. Thank you so much.
Thank you, sir. I would now like to introduce our guest of honor for the evening, Mr. Tushar Mehta, Solicitor General of India. Mr. Mehta began his career as an advocate in 1987 and was designated as a senior advocate in 2007 by the Gujarat High Court. In 2008, he was appointed as the Additional Advocate General, and in 2014, he was appointed as the Additional Solicitor General of India. He was later appointed as the Solicitor General of India in 2018. With this, I would like to invite Sir to give the address to the crowd. Thank you.
A very good afternoon to all of you. My Lord Justice Vikram Nath Sahab, my friend Mr. Desai, Neeti, friends in the audience. I am conscious of the fact that we are meeting at this juncture where mentally we should be, or we are, at somewhere else. Keeping that in mind, I'll curtail my time. Friends, I wanted to share two thoughts which has repeatedly occurring in my mind since last about 1.5 years, because 1.5 years have been the period where we have seen several arbitration-related seminars, etc. going on, some of which I happen to participate in. First, the focal point of every discussion in every arbitration seminar is how to westernize the Indian concept of arbitration. Basically, arbitration is necessarily an Indian concept. It is accepted, formalized, and put into a kind of a statutory framework elsewhere, depending upon their needs, their requirements, and their issue-specific problems. We always discuss how to do it in tune with UNICITRAL model law, what is the position in Singapore law, what is the position there, and how to bring about changes in our law. But unfortunately, if you give a thought, give a serious thought, you will find that we have not been able to come out with our Indianized version of UNICITRAL model law or Singapore law, or for that matter, any other law. It is time now for a vibrant people like Neeti to start working on that and ensure that there is some churning of mind, some deliberations, some meeting of minds, intelligent, brilliant minds put their head together and come out with something which is not only relevant in the Indian context of business, but is also acceptable to other jurisdictions of the world, because we are not confining ourselves to arbitrations within India. We both have domestic and international arbitrations. So we must have our own model law based upon which not only our arbitrations are governed, but that can be a preferred law of arbitration for even international parties. To my knowledge, I don't think any such attempt has so far been made, at least in a formalized way, where all brilliant minds on the subject come together, discuss, put forward their viewpoints, put forward their ideas, give their suggestions, give their models, and something can emerge out of it. Second, I'm not aware what happens after such beautiful events conclude. There has to be, in my view, someone writing down whatever is discussed, whatever is suggested, whatever was shared by the experts, and thereafter to analyze, are we in a position next year, by next year, within next year, to implement any of them, any of those ideas, or to consider those ideas and say that this idea may not be acceptable for ABCD reasons. If it is not being done, I think this is a good occasion where a beginning can be made, where someone who has attended all functions and who has been a part of every event can write it down, what has happened, what were the good suggestions given by several experts, domain experts, and what can we do, what can we do to have a way forward. These are the two suggestions I had to make. You are all brilliant people, you are all people associated necessarily with arbitration. I sometimes do arbitration. I cannot claim myself to be a lawyer practicing on the arbitration side, but when such brilliant minds are under one roof, it is time that we start thinking about our own system. And when I say our own system of arbitration, I do not for a second say that we discard whatever is the international scenario. No, that's not the idea. The idea is to come out with an indigenous, a domestic model law which caters to our need and which can also fit into the problems of international community. That is something we are lacking in. That's what my personal feeling is. I may be wrong, I may be right. But if I am right, it's time something needs to be done. Friends, I don't wish to take any longer. I'm indeed grateful for the organizers, Mr. Desai and Neeti, to be always kind to invite me with all my limitations on the subject. And I thank all of you for being a very patient and very considerate listeners, despite the circumstances under which all of us are sitting here. Thank you so much. Thank you.
Thank you, sir. I would now like to introduce a chief guest for the evening, Honorable Mr. Justice Vikram Nath, Judge of the Supreme Court of India. Justice Nath practiced as an advocate for 17 years before he was appointed as a judge in the Allahabad High Court in 2004. In 2019, he was appointed as the Chief Justice of the Gujarat High Court, and it was in 2021 that he was elevated as a judge to the Supreme Court. With this, I would now like to invite Justice Nath to give the keynote address.
Namaskar, good afternoon. Guest of honor of today's valedictory function, Mr. Tushar Mehta, Learned Solicitor General. Mr. Desai, Ms. Sachdeva, founders of MCIA, distinguished guests, ladies and gentlemen. After hearing Mr. Desai and Mr. Mehta, I am in a state of complex. They have spoken without any piece of paper, so eloquent in their delivery, with so much of content. So in order to match them, I have prepared a long note for all of you, and you will have to suffer for me. Because I told Tejas, give me 5 minutes to speak, he said, no, half an hour. Ultimately, we compromised to 20 minutes. So now I can't cut down that speech of 20 minutes, you will have to hear. All right, ready? Very good. At the outset, I would like to thank the organizers with a deep sense of gratitude to have given me this opportunity and the honor to be here as the chief guest. And in particular, I wish to thank Mr. Tejas Karia. We gather today at the conclusion of the third edition of the India ADR Week. It's a moment of reflection and anticipation. Reflection on the week gone by and anticipation for the path ahead. This event has brought together a diverse spectrum of thought leaders from India and abroad, fostering an environment of learning and exchange on arbitration's contemporary themes. Here I would like to talk about the father of our nation, Mahatma Gandhi, who was also a strong champion of principles of alternative dispute resolution. Gandhi firmly believed that the essence of law was not to create rifts, but to amend relations. Drawing from his experiences, such as his time in Durban, where he advocated for a more amicable solution in a recovery suit by his client Sheikh Abdullah, he realized that pure justice sometimes lay outside the courtroom, and despite winning the suit and a hefty lump sum, Gandhi convinced his client to accept the payment in installments instead. It wasn't about the singular victory, but the collective harmony. In his autobiography, Gandhi recalls his time in South Africa, emphasizing the potential of arbitration to resolve disputes. He recounts, "The lesson was so indelibly burnt into me that a large part of my life during the 20 years of my practice as a lawyer was occupied in bringing about private compromises of hundreds of cases. This emphasis on recollection and reconciliation over victory is mirrored in his Satyagraha movement. He viewed conflict not as a battle to be won, but as an opportunity for mutual understanding and growth. The relevance of this week cannot be overstated. The vibrancy of the discussions, the depth of the debates, and the vision of the dialogues reflect the dynamic nature of arbitration in the contemporary world. As we converge from different backgrounds, our shared commitment to the evolution of arbitration remains unwavering. We have engaged in profound discussions on a range of pivotal topics, including the enforceability of orders from emergency arbitrators, the integration of technology and artificial intelligence in the arbitration process, the dynamics of third-party funding, the scope and limits of judicial intervention in arbitration, determining which disputes are suited for arbitration, best practices for managing disputes efficiently, and lastly, the latest modification to India's mediation framework. Globally, we have seen waves of change redefine the landscape of dispute resolution. But closer to home, in India, these winds of change have been even more pronounced. Before we dissect our progress, innovations, and future plans, let's take a moment to understand and appreciate the strides taken so far. The Indian legal system, with its vast and intricate fabric, has always had arbitration woven into its threads. Yet, recent years have seen this method of dispute resolution emerge from the shadows, becoming a forefront player in resolving commercial disputes. Several deliberate steps have been taken to achieve this prominence. Firstly, the global shift towards institutional arbitration is evident. While ad hoc arbitrations have their merits, the value of institutional arbitration, with its set protocols, pre-established rules, and expert assistance, has been increasingly recognized. Institutions like the Mumbai Center of International Arbitration are at the forefront of this transformation. Their endeavors, fueled by commitment and expertise, have showcased the unparalleled advantages of systemized dispute resolution. Legislative frameworks have also played a crucial role. The Arbitration and Conciliation Amendment Act of 2019 stands as a testimony to India's intent to create a more streamlined and user-friendly arbitration environment. It's not just about speeding up processes, it's about enhancing the quality, ensuring predictability, and fostering confidence in our arbitration ecosystem. But laws alone cannot bring change. It's the interpreters of these laws, the judiciary, that breathe life into them. Time and again, our courts have bolstered arbitration in India, not just by deferring to arbitral awards, but also by promoting arbitration as a genuine, efficient alternative to traditional litigation. When we talk about an evolving arbitration landscape, it's imperative to touch upon the role of emergency arbitrators. Traditionally, the concept of interim reliefs in arbitration was linked to the national courts. But as international commercial transactions grew in complexity and speed, there arose a need for a mechanism that could provide immediate reliefs even before the constitution of the main arbitral tribunal. This gave birth to the concept of emergency arbitrators. In the global arena, the role of emergency arbitrators has gained significant traction. They represent the very essence of modern-day arbitration, swift, specialized, and efficient. The recent Supreme Court judgments in the Amazon.com in Future Retail Limited is monumental in this respect. By upholding the sanctity of orders passed by emergency arbitrators, our highest court has signaled India's alignment with international arbitration standards. Yet for these orders to truly have the force they deserve, we need more than just judicial endorsements. We need legislative amendments and institutional rule changes that recognize, support, and provide a framework for emergency arbitration. In an era where technology defines the way we live, work, and communicate, it's only fitting that arbitration embraces the technological tide. The COVID-19 pandemic, in particular, served as a catalyst, necessitating remote hearings, virtual sittings, and digitized documentation. Digital platforms have democratized access, breaking geographical barriers and making arbitration more inclusive. With tools like AI-powered analytics, predicting arbitration outcomes, gauging tribunal behaviors, and crafting legal strategies have taken a quantum leap forward. Online dispute resolution platforms have carved a niche, especially for low-value disputes where costs and efficiency are paramount. They are not just the future, they are the present. However, with the embrace of technology comes the need for caution. Cybersecurity concerns loom large, and the sanctity of proceedings must be preserved. Confidentiality, integrity, and availability, the CIA triad in cybersecurity, need to be our guiding stars. Institutions and practitioners must invest in robust technological infrastructures and constantly update to stay ahead of potential threats. The landscape of arbitration is rapidly evolving, and one of the significant developments in this arena is the advent of third-party funding, TPF. TPF at its core is a testament of the very essence of arbitration, accessibility, and efficacy. As the costs associated with arbitral proceedings arise, particularly in complex international disputes, TPF ensures that deserving parties aren't shut out of the process due to financial constraints. It's not just about leveling the playing field, it's about expanding the arena. However, TPF is not without its critics. Concerns regarding potential conflicts of interest, transparency, and undue influence by funders have been raised. It's imperative that regulations evolve to address these legitimate concerns. A robust framework that ensures transparency while preserving the autonomy and integrity of the arbitral process is the need of the hour. As India grapples with these challenges, it can look to jurisdictions like Singapore and Hong Kong, which have already taken strides in this direction. Judiciary plays a paramount role in shaping the arbitration landscape of any nation. In India, the judiciary's approach has been proactive, facilitating, and in many instances, pioneering. Over the past few decades, we have witnessed our courts consistently favor an arbitration-friendly approach. Landmark judgments have emphasized non-intervention, upholding the sanctity of arbitral awards, and stressing on minimal judicial interference. The celebrated Bharat Aluminium Company versus Kaiser Aluminium Technical Services is a testament to this, where the Supreme Court clarified the non-interventionist role of Indian courts in foreign-seated arbitrations. Moreover, the Apex Court in its various pronouncements has reiterated the importance of institutional arbitration, emphasizing its advantages over ad hoc mechanisms. These judicial pronouncements not only pave the way for a conducive arbitral environment, but also send a positive signal to international investors and stakeholders about India's commitment to upholding the rule of law. The heart of arbitration lies in its commitment to offer a swifter alternative to the often lengthy traditional litigation. To truly ensure that arbitration is efficient, we must be relentless in our pursuit of enhancing its process. One way is through robust case management. Holding early case management conferences can truly set the tone and provide a clear roadmap for the entire arbitration journey. Embracing modern technology is another. Whether it's using e-discovery tools or conducting virtual hearings, technology can significantly reduce delays. Another vital aspect is training and development. By offering continuous training, we ensure that arbitrators are well prepared to tackle complex disputes with efficiency. Lastly, it's crucial that institutions maintain clear and regularly updated procedural rules. This minimizes any chance for procedural ambiguities and further streamlines the process. India's commitment to mediation cannot be overstated. A look at the recent data from the National Legal Services Authority, that is NALSA, underscores this commitment. 464 ADR centers, 570 mediation venues, and an impressive roster of 16,565 mediators. These figures alone speak volumes about the rising prominence of mediation in our nation. The Mediation Act of 2023 introduced several transformative changes. For example, assigning legal status to mediation agreements, promoting pre-litigation mediation, introducing provisions for courts to recommend mediation even in ongoing litigation, incorporating digital mediation, placing a significant emphasis on institutional mediation, establishing the Mediation Council of India to draft the guidelines and enforce the best practices on a national scale. Looking to the future, the groundwork laid by the Mediation Act, combined with the endorsements from our judiciary, paints a hopeful trajectory for mediation in India. With these solid foundations in place, our collective focus ought to shift towards achieving broader acceptance and positioning mediation as the go-to choice for dispute resolution. Arbitration in its role as a favored avenue of alternative dispute resolution has undergone significant transformation in India. Yet, for it to reach its pinnacle and become the primary tool for resolving commercial disagreements, we must confront its challenges and seize the forthcoming opportunities. As outlined in the deliberations during IAW 2023, there are some pivotal measures for enhancing the future of arbitration in the nation. One of the salient recommendations is the shift from ad hoc to institutional arbitration. We urgently need to foster and champion premier arbitration institutions within our borders. In this context, entities like the MCIA can be exemplary. The inception of centralized repositories detailing seasoned and adept arbitrators would streamline the selection process. The vitality of having adept arbitrators and professionals cannot be overstated. Regular training modules should be both introduced and mandated. There is an imperative to engage academia by integrating specialized arbitration modules into legal studies. We can cultivate a fresh wave of adept arbitration practitioners. Harnessing technological strides can vastly enhance the arbitration mechanism. We must also address and elucidate any nebulous provisions within our current framework, ensuring the arbitration process is seamless with minimal external interference. For specific dispute categories, the introduction of a well-defined fast-track procedure is crucial, paving the way for timely resolutions. A parallel focus should be on infrastructure development, investing in the state-of-the-art facilities for hosting arbitrations, positioning India as a coveted arbitration destination. In conclusion, the path ahead for Indian arbitration is crystalline: robust institutional backing, ceaseless skill enhancement, legislative precision, technological integration, and a globalized perspective. By implementing these strategies, India stands poised to revolutionize its arbitration sphere, consequently enriching its commercial fabric and amplifying its international stature. As we reflect on the myriad themes discussed during the India ADR week, one thing stands clear: the future of arbitration in India is bright and promising. From technological advancement to the push for diversity, from the rise of third-party funding to the emphasis on specialized institutions, India is at the cusp of an arbitration renaissance. The way forward requires collaboration. Institutions, practitioners, academicians, and the judiciary must come together, learn from each other, and shape a robust, inclusive, and efficient arbitration ecosystem. India has the potential to be not just a major player, but a leader in the global arbitration arena. Let's harness the insights and learnings from this week and propel Indian arbitration to new heights. Let us remind ourselves of the insight offered by Abraham Lincoln, who aptly encapsulated the essence of our discourse today. He said, "Discourage litigation, persuade your neighbors to compromise whenever you can, point out to them how the nominal winner is often a real loser in fees, expenses, and waste of time." As we forge ahead in promoting and upholding the principles of ADR, let's carry this wisdom with us, recognizing the true value of peaceful resolutions over contentious battles. The journey has just begun, and together we will chalk out a path filled with promise, progress, and unparalleled success. Thank you. Thank you very much.
Thank you, sir. I would now like to invite Ms. Neeti Sachdeva, Registrar and Secretary General of the MCIA, to give the vote of thanks.
Thank you, Honorable Justice Nath, Mr. Tushar Mehta, friends, ladies and gentlemen. Let me begin by saying this: there are certain causes in our life which are so close to our heart that it becomes a part of our DNA. And I can clearly say that one cause very close to my heart has been promoting institutional arbitration in India, and to say that India has to be the place for arbitration. To that effect, IAW, as Madhukeshwar said, was something that we decided, got on the table, thought will work, will not work. And I'm so glad to see that we have finally been able to manage to have 6 days, not even a week, 5 days is what happens internationally, but 6 days of discussion, deliberation, going around the 3 cities, and finally culminating it here, and having the privilege to actually close the proceedings on the IAW today. Mr. Mehta spoke about 2 things, sir, and I would like to tell you what we are doing on that. One, he mentioned that these conferences should not conclude here with all of us just enjoying our company and then forgetting about what happened. In fact, sir, what we have done is that we have 2 reporters, in fact, Ritika Bansal and Matthew Brown, who have traveled with us for all these 35 events, sat down for this, and are preparing a report to summarizing what were the discussions, what came out of it, what needs to be done from there, and we will share a copy with you, and we would love to have your comments on it as and when you have time. Of course, along with those reporters, we also have the live transcript, so all the transcripts are going to be there as well, and I welcome each one of you who have not been able to travel with us through the 3 cities triathlon, have attended only few of them, but if you get an opportunity, would like to comment on something, MCIA Secretariat is always happy to have your comments and to take it forward from there. The second thing that Sir talked about is that MCIA rules and MCIA, should think about having the India best practices as well. Though I agree with you on that, sir, that India should be leading the effort on it, but I can tell you that with MCIA, we have tried to bring in the international best practices, but not westernize the concept. We have kept the Indian culture ethos into the practice of arbitration as well, and one very distinguishing feature in our rules, which no other institution rules has it, is that a presiding arbitrator in an MCIA arbitration is always appointed by the institution, which is to bring in the neutrality and the independence of the arbitral process itself. Justice Nath talked about emergency arbitration. Sir, we're happy to tell you that we have done 2 emergency arbitration orders already in a short span of 7 years. And none of them has been challenged, but actually voluntarily been agreed upon by the parties. In terms of technology, MCI has always been in the forerunner, not only COVID, but I can tell you even pre-COVID, we used to do all our procedural hearings virtually. Of course, people have taken it up now even more post-COVID, and MCI arbitrations are all done virtually, except when the parties and the tribunal all want to do it physically, which of course we discourage to the extent possible. The third thing that Sir spoke about was, of course, the case management tools. And Sir, I'm very happy to tell you that we have a dedicated case manager, Charvi, who looks into it on a day-to-day basis. And of course, we use our tech tools like the Tribunal Secretary course that we just concluded, whereby we will make it more efficient for the arbitrators to use the Tribunal Secretaries, have the case management done, and make sure that we continue to have a record of finishing our awards in less than 18 months. I will not take much of your time, but I will just conclude by saying this, that this has been one of the most satisfying weeks for me. 35 events, 3 cities, 600 participants, 120 speakers, more than 15 countries represented here in this room today. And this all would not have happened without the support of each one of you here, but also the support of our sponsors and supporters. We have almost 25 different organizations supporting it on more than 25 foreign and domestic firms supporting the India ADR Week. We will be back with you in 2024, bigger, larger, as Madhukeshwar said about it, and that will not happen without the support of each one of you. So once again, thank you very much for sparing your time to be here and to celebrate India as the ADR jurisdiction. Thank you very much.